having any contact with your client. And for the time being, as long as those parents are willing, that's probably the best thing. I don't assume that they assaulted Mr. Richter.
Yes, Your Honor, that seems fine.
All right, so he will pick up when it's his time from the parents, and the parents will pick up from him when they're getting their time. All right. Now, both parties have also talked about mediation, I think, or whatever, or maybe that's just my own deal. What about, I think I'm gonna order mediation in this case. Because we don't have a hearing until April. And there's no reason that this shouldn't go to mediation. I guess what I will say also is that I'm gonna order mediation, and parties have 7 days to agree upon a mediator and set that up promptly. And see what can be done. Now, the only problem with mediation is the parties do have to probably be in the same room or something, or in the same area together. And the only reason mediation would not take place is if it's prohibited through her, she's on probation. If the probation officer says no for mediation, that you can't, then I will relieve you of that requirement.
Thank you, Your Honor. I would assume we could do it via Zoom and not have any contact if necessary.
And that's, but if that can't be done, then then that part of the order will be null and void. Mr. Vollmering, any thoughts on that? Does your client object to mediation?
No, Your Honor.
Can I leave it up to the two attorneys to pick a mediator within a week?
Yes, you can.
Yes, Your Honor.
All right. Good luck. Thank you very much. That's the order of the court now.
Thank you.
Thank you.
Have a good weekend. Thank you.
Oh, I'm sorry, Your Honor, real quick.
Yes.
When is my client's parenting time scheduled to begin? This, I understand we have Thursday through Sunday, but today is Friday, so is he gonna exchange back on Sunday then?
He has the child now, doesn't he?
I believe so, yes.
Yeah, so he'll have till Sunday, and then the next week he'll start on this coming Wednesday. He'll start on this coming Wednesday.
Perfect. Thank you.
And the next week he will have Thursday and so on. Okay.
Thank you.
Right. Good luck, everybody. Thank you. We're adjourned.
Thank you.
Margaret?
And two, but I don't know the answer before I start doing.
Okay.
Morning.
Because they were not here before.
Get a cup of coffee. We're gonna settle in.
Okay. Fields.
I don't know. It's a bad sign. That first group was
Somebody identified as iPhone. Can you hear me? And if so, you're on mute. Can you tell me your name, please?
represented and rational.
Are they connected? We have someone on the screen identified only as iPhone. They're on mute. What is your name, ma'am?
Paris Williams.
All right, thank you. We're gonna rename you. We're gonna put you in the waiting room. I've got a lot of hearings today, so kind of be ready. We'll get to you as quickly as we can.
Okay.
Thank you. Sir, what is your name, please?
Joshua Bennett.
All right, Mr. Bennett, do you have this case? All right, sir, we'll get you on as quick as we can. We're gonna rename you. We're gonna put you in the waiting room, and I will get to you as quick as we can. We've got a lot of hearings today, and as soon as we get, paired up people, we try to get them in. So I'll get to you as quickly as we can. You're welcome. Because you don't have Van Dyke, you have. You don't see Fields anymore?
There were drugs involved that were given to me that ended up being glue.
Ms. Romo, can you hear me all right?
I can. Good morning.
Good morning. We had Mr. Fields on, but he is apparently logged off. We don't have Miss Van Dyke. Well, all right. It's almost 9 o'clock. Mr. Fields, as I say, was on at one point, but is not. Do you mind if we put you in the waiting room for another 10 minutes or something and bring you in, see if he logs back on? If not, we'll take you and get it done. Okay?
Yep, that's fine.
Thank you. All right, if I know what that 16. No, I got it 16. I had it memorized earlier, but I lost track. All right, everybody out there in YouTube land, Missy, Cheryl, whoever's all out there, good morning to you. One day. Allison, who did the heavy lifting last night.
Good morning, Your Honor.
Good morning, Ms. Brower. How are you?
Good, and yourself?
Fine, thank you.
Good.
Nobody is logged in on your case. What did you do to him?
Nothing.
This is case 23-6995-DS. It's the matter of Ortiz versus Young. We have neither party who has been logged in, but they have been notified about this matter. It was set for 8:30. We're now at 9 o'clock. And as I say, no one is even logged in.
Mhm.
So we're going to proceed. This was a request from Ms. Brower, who is present, from the Kent County Prosecutor's Office for a judgment of support. I believe you called for just the have it here. You have listed 78 overnights for the father with the child, and have used that to calculate. You have calculated the plaintiff, Miss Ortiz, with potential income, basically finding that she is a CNA, has a high school diploma, has some work in that field, believes she's available, and you have imputed her at $17 an hour times 35 hours, which seems reasonable considering she does have her certified nursing assistant certificate. You have imputed the father, who has he has a high school diploma. I've gone through the factors. He appears to be in his late 20s. You've imputed him at $14 an hour, having had some past working experience. Looks like his holding and Dexco, Enviro Clean building, things like this. So he does have a past work history. There is clearly in this area the ability to get a job at almost any place, such as Wendy's or McDonald's, for $14 an hour. You've imputed him at $14 an hour times 35 hours, which is generous. As a result, you've asked for the court to enter the UCSO. That would make $363 from Mr. Young to Miss Ortiz. I believe those numbers are correct, and we'll enter that. Is there anything you would like to state?
Just for the record, Your Honor, there was a pre-hearing conference that I scheduled for January the 9th. I called the plaintiff twice. She did not answer. The defendant did answer when I called him, but told me that he could not talk because he was with the customer. So apparently he is working. I just don't know where. And again, I am asking that the court enter the proposed judgment as well as the UCSO.
I will do so as soon as you send it to me through DocuSign.
Thank you so much, Your Honor. I appreciate it.
Thank you. Have a good weekend. Take
You
care.
do the same. Bye-bye.
Come on, Judge, bring on the crazy. Don't make me play. It gets worse again.
You know, Mike Tobierin's here for, okay.
Good morning.
Good morning, Mr. Tobierin. How are you today?
I'm good. How are you?
Good, thank you. We're
How's
trying to
your,
get down the parties on here and we'll get right to you.
Sounds good. Maybe.
Yeah, sounds good, but execution is lacking a little bit here.
Got that. All right.
Ms. Smith, can you hear me? It looks like you're logged on, but you're on mute and I don't have any video.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
Can you see me now?
Yes, I can, and I can see you and hear you.
Oh, perfect. Thank you.
Mr. Tobierin, okay, your client just logged on.
Yeah, I see that as well.
Mr. Smits, can you hear me and can you log on with a video, please?
To me that ended up being glue. Like I smoked some glue
Me?
and stuff. I thought it was
Yes.
There you go.
All right, this is the matter of Smits v. Smits 21-10978 DM. Both parties are present, as well as Mr. Smits' attorney, Mr. Tobierin. This is a request from the mother, the defendant, says it's stated as custody. However, I have to agree that it sounds more like a change of domicile than custody. As you've requested, ma'am, to be able to move outside the 100-mile limit, about 160 miles away. There was a judgment of divorce that was entered that provided for joint legal custody and even states in paragraph 7 deals with change of domicile. You're kind of asking for week on, week off, but literally you want to change the child's residence to over on the east side of the state, which is you got to request a change of domicile. I mean, I note that I'm not, the statements that I hear, you want to change domicile, but you want to make week on, week off, but you're going to spend 2 days then your week here and then spend the other 5 days over on the east side of the state. Is that what you're asking for?
So I am going to be coming into the office every Monday. I have to work Monday and Tuesday, so I would come
Not
back
yet.
on Sunday.
I'm working on
And
it.
my plan is to stay at my mom's house with Grace, who they have a very great relationship.
I understand.
And then the rest of the week I would be on the east side of the state from Tuesday through Sunday. We would be
No.
coming back every Sunday
Oh, we can have
But
it.
then the next week, Mr. Smith would have your child for a week.
for a whole week. Correct.
Well, you are asking for a change of domicile and with joint legal, I'd have to determine if it's in the best interest of the child and whatnot. For that, we'd have to have an evidentiary hearing for that change of domicile. Unless Mr. Smith agrees to it. He can always agree to it, but Mr. Tobierin has filed an answer in which he clearly doesn't agree. So we'll have to have an evidentiary hearing for that. Mr. Tobierin, anything on that issue you wish to respond to?
Love it.
Well, Ms. Smith and I have not discussed this. I would certainly think we should talk before we have an evidentiary hearing. This child, is 16 plus
16.
years old. It just seems outrageous that we're going to potentially uproot her at that age and have her live in 3 different homes. And as I put in my response, she's been primarily living with my client since August anyways.
Well, I have to have an evidentiary hearing if there's a request for change of domicile with joint legal custody. So, and that's what the request is to move her outside the 100-mile limit and basically have a change of domicile is with mom. So you will not get a hearing in the next week or two. So you got plenty of time for the parties to discuss the matter. And see what happens. What grade is this child in?
She's in 11th grade. I put together a little thing. I don't know if I'm allowed to read it off to you.
What,
To
regarding what?
this whole situation.
What are you trying, I mean, you filed a motion and you're asking for a change of domicile. Is there anything in there? I can't make a ruling on change of domicile today, no matter what you tell me.
I don't really feel like it's a change of domicile because she's going to be spending the majority of the time in Grand Rapids. So I didn't feel that that was the appropriate way to go. And when I went to the clerk's office on the 5th floor, I think it was, and I told them the situation, this is the paperwork that they told me that I needed to fill out.
Well, even assuming it's not, you're saying it's a change of custody, okay? A change of custody, I'd have an evidentiary hearing about that also.
And I would also note that she's actually requesting by court order that my client have more parenting time. So it's,
I understand.
it's
I don't-
clear, I mean,
But I think my huge hangup is Rick states that Grace has spent the majority of her time since August 1st with him. And that's not true. I have dates of the times that she has gone with him. There was a strained relationship between April 4th and November 4th. Grace had only 8 overnights with her dad when she should have had 60. In the last 3 months, things have improved with the relationship, and she has had 37 overnights, 7 more than the court allowed.
And I can't change custody or domicile, whatever we set it as, on a Friday morning. I can only set an evidentiary hearing because they're objecting to this change. And whether you call it custody or domicile, it really, from a standpoint of what I can do on a Friday morning, I cannot agree to say go 50-50. Only the child live with you for like 2 or for a week, 2 days here, 5 days in Detroit, and that kind of stuff. You can negotiate anything you want. In fact, I think we should refer this to mediation because the parties need to sit down and talk. Quite frankly, the child's 16 and in 11th grade. A lot of consideration is going to be given to the child. But I can't do that here, and nor will I do it here.
Okay.
So we'll just set that for an evidentiary hearing regarding custody / change of domicile. You'll get some time, but it's not going to be for a month, 2 months. I'd imagine it'll be in April or something before you're going to get time. We don't have a lot of time available, so we'll set an evidentiary hearing regarding that. Can the parties agree on going to mediation for all this?
I will do whatever it takes.
Sure.
I have to make a financial decision. I'm drowning in every month that goes by.
Well, I mean, you can still, I don't know how to say it. You don't need an order if you want to leave the child here with him and you go over there for some time or something. I don't know what. You talk to Mr. Toburin about it. Maybe you guys can work something out. So we'll set up an evidentiary hearing on that. You've also asked for a child support review, ma'am, stating that I believe the last uniform child support order was in August 31st of 2022.
Correct.
You say that the father's making more money, that he's changed jobs. Mr. Toburin, what do you know about that, or your client, Mr. Smith's, whatever?
my client, at a very basic level, denies that claim.
That, does he have a different job since August 31st of 2022? Mr. Smith, you still working at the same job?
Yeah, I do have a different job since that day, yes.
And the reason you changed jobs?
Actually, my previous job was considered a part-time job, and this is considered a full-time job.
And it would seem like you're probably making more.
Very little more.
Well,
And the claim of me not turning in the correct
that
wages.
doesn't matter to me. That
Okay,
doesn't matter to me
okay.
at this point. I'm just saying that it's apparent that you have changed jobs. We'll refer that matter to the friend of the court for a child support review.
Okay.
All right. Next request was for medical bills that Ms. Smits has requested. And basically, ma'am, there's a whole process that's set up through the friend of the court. Have you gone through the friend of the court handbook type stuff? You submit it to him. If you don't get it, then the percentages that are required on the child support order, if you don't get it, you submit it to the friend of the court. And if he doesn't pay it and that kind of stuff, I mean, I'm not going to order him because I don't know what it is owed and stuff like that. I have no idea.
Okay.
So
I will, thank you for that information. I will go that route.
follow the friend of the court. And the final matter is a request. I should say, Mr. Tobier, and you don't have any problem with that as far as the medical bills. She just has to follow through on what she has to do.
No, I agree. I don't have any documentation to say yes or no, that that's a legitimate claim. So I don't disagree that the process should be followed.
All right. And finally, she wants something like an app to communicate with your client. Ma'am, can you communicate them with text or something like that? Or do you need some app to go through?
I feel like it would be a good idea so that we're all on the same page and there is not, there's a lot of not pleasant things. And it would be nice to have the court like monitoring that so that.
Not gonna monitor it. You're gonna have to, you'll have to file a motion or something to do it. I mean, I'm not gonna watch what you guys do until it's brought to me.
Yeah, my client, I don't like the idea of, forcing an expense on my client. I don't see any
There,
of poor
there are
communication.
apps out there now that are not, that do not cost, I think.
Well, I thought the court had the Wizard app and there was no cost
Our
and
Family Wizard is an app that's out there, but it has a cost to it, as I understand it.
It does.
okay.
And if you want to pay for the cost, you can do it.
She just wants to rake him over the
But I'm
coals.
assuming you don't want to. There are other apps, Mr. Tobier, and I believe there is one, I can't come up with the name that I thought did not cost.
I think it's app close.
Yes, bingo. Why can't we use that?
I will use whatever. I just
don't think it's
there's
probably not a huge deal, whether they text or whether they go through the app. It just doesn't seem like there's been a real problem. And again, the daughter is 16 years old and I'm sure she has her own cell phone and I don't know what the point of it.
Too, and all that kind of stuff. I'm not sure what the value is, but if somebody usually wants to use app close and it doesn't cost, I mean, it's hard for you to argue against it.
Yeah.
There's not anything. So you can use the app close to communicate, put it on whatever it is, wherever you get it.
Yep.
All right. So
Thank
we
you.
will set up an evidentiary
All the rest
hearing
of it is
regarding the
harassment
custody, change of
on
domicile
that goal.
request, friend of the
That's
court.
what's going on.
We
Plain and
will
simple.
draft that and send that over to the friend of the court for the child support. The medical bills is, I mean, it's not, I don't know what to say. I guess I deny your request for that, although you will go to the friend of the court and we will grant app close being used. Mr. Tobieren, can you draft that order quickly?
Yes.
There was one more thing that was on my list, and that was the insurance, carrying the insurance to see if Rick would be able to carry her on the insurance. Currently, I'm paying the full premium plus 60% of medical on an uncovered
But
medical.
you also get credit for it on child support.
Yep.
And so does Mr. Smits have the ability to carry?
Yes, I can add her. It's just,
Yeah, then
my
deduct from the child
response is
support credit.
it's already being funded, I guess you want to say, by my child support. So I want, she
Scrounging for cash.
She
plain and
originally
simple.
wanted her on her insurance to begin with. I don't understand why we have to change it now. I'm
You
already.
requested
Because-
it.
You didn't have insurance at the time.
Well,
Court can address that too, if they're gonna review child support.
yeah, we'll deal with that at the time of the child support review. See
Okay.
see what we can do. You can talk to the person who reviews it. Please make sure that you are in contact with the friend of the court when they contact you regarding
I know all about
child
it.
support. Provide that information to them, otherwise I'm gonna who knows what I'll do, but it never goes good against somebody who does not provide information to the friend of the court. All right? Good luck, everybody. That'll be the order of the court. Mr. Tobiern, you can send it in under the 7-day rule, which means, ma'am, when you get it, if Mr. Tobiern has done anything in there that is not what my order is, doesn't mean whether you agree with it or not. It's just whether he put into the written order what I have ordered, okay? And you can object to it. If you do, you're gonna have to set it up for a hearing and show why. All right?
So there's nothing that I need to do. I do not need to go
No, but
file
you-
any.
No, but what you do need to do is when he gets that to you, you've got very limited time, 7 days to object. And if you object to that order, you better have specifics about it. All right? Good luck, everybody.
Thank you.
Have a good weekend.
You too, thanks.
Mr. Sharps. Mr. Sharps. Mr. Sharps. Mr. Sharps.
Good morning. Can you hear me okay?
Phone number that ends in 52. Can you hear us?
I never want to hear it again. You're not a whore. You're not a whore.
Is it Mr. Fields?
Want to hear it again.
Hello?
Oh, I'm sorry, hello?
What's your name?
Aaron Fields?
Mr. Fields?
Yes.
Right. And, all right, stay on for a minute. Miss,
Okay.
yeah, we have somebody who's just identified his iPhone, ma'am. What's your name, please?
Paris Williams.
Oh, yeah, we had here. Did you log
Yeah.
out or something?
It keep on dropping.
All right, well, we'll put you back in there and we'll get to you.
Okay.
Thank you. We can pull in Margaret. All right, we're here in case 23-9262 DP. It's a matter of Van Dyke versus Fields. We have Mr. Fields on a telephone on the Zoom account here. We also have Ms. Rummel from the prosecutor's office. The plaintiff, Ms. Van Dyke, has never logged in. This is a motion brought by Ms. Rummel regarding a judgment of paternity. For entry, it's clear. Mr. Fields, did you get a copy of the DNA test?
Yes, I did.
It shows you're the father. You understand that?
Correct.
All right, then we will enter a judgment of paternity. The second issue that we have to deal with relates to
You did it, brother.
child support. And that order that has been presented by Ms. Rummold says that you have actual income that she's been able to see at $16.50 an hour times 40 hours. So that figure is used for your income. Mother, Miss Van Dyke, we don't have information about her, but the prosecutor has entered a potential income for her at minimum wage at $10.10. Now, she stated, Ms. Van Dyke stated that she estimated that she earned $200 a month at some point. based on babysitting and stuff. She has no high school diploma or GED. Very little is known about her. I assume, Ms. Rummel, that she was not forthcoming with much information.
No, during the pre-hearing conference that was held December 12th, she did state that she had sort of an unlicensed daycare or a babysitting gig where she took kids in, but it depended on how many kids she got. And it was about that $200 a month that she earned from that endeavor.
All right, well, quite frankly, nowadays, the unemployment around here is virtually nothing. Fast food places and stuff are looking for people all the time to fill, usually at $13, $14 an hour. I don't see a reason why she should not be able to make that kind of money. And so imputing her at minimum wage at $10.10 times, I guess I would say, looks like you imputed her at 20 hours a week. Is that correct?
I put her at 35 hours a week.
And do you have a job when you're not in custody?
Yes, I do have a job.
Where do you work?
Yeah.
Where do you work?
Oh, I work, I sell burritos sometimes.
Appropriate after going through the factors that you imputed her at 35 hours times 1010 and use that for the calculation. Sir, do you have anything to say about the uniform child support order?
We agreed on like, it was like $300 or something like that.
Well,
So that's all I was trying to say. I don't know.
all you have to come in with a reason for deviation, and the court will probably agree with it, but we don't have anything from her to indicate that she agreed to it at this point. So,
Okay.
so the amount that I will order is the $429. If the two of you can agree, I mean, actually can give you, if you're paying it, she can give you back some money. But there is state assistance being used, so I'm not sure what part goes to her and what part goes to the state as it is. So you can't make an agreement to short the state for money. All right. So you guys can work on that and see how you do that. I'll enter the two orders, Ms. Rummel, when you send them to me via DocuSign. Okay.
Thank you very much, Your Honor.
Thank you. Thank you, Mr. Fields.
Yep, thank you.
Good luck. Thank you.
Congratulations. You're paying $420 a month.
Number 6. It's just the plaintiff. And has an.
And there is an interpreter. Mr. Romero, good morning.
Good morning.
While I got you, can you raise your right hand? You solemnly swear to interpret to the best of your ability and not divulge confidential communications.
Yes, I do, Your Honor.
Thank you very much. Miss Coronado, can you hear me?
Señora Coronado, ¿me puede escuchar?
You're on mute, so you'll have to unmute.
Tiene el botón de mudo, o sea que tiene que quitarle el botón de mudo. O el del micrófono.
There you go.
¿Ahora sí?
No, ahora sí.
Okay.
Sí, le escucho. Yeah, we can hear you.
All right. We have Mr. Romero here to interpret for you, okay?
Y tenemos al señor Romero que le va a traducir hoy, ¿está bien?
Sí, gracias.
Yes, thank you.
All right, thank you. This is case 19-7519.
Ese es el número, ¿qué número de caso? 19-79.
Coronado Vega versus Guzman.
Coronado Vega contra el señor Guzmán.
This is a motion by the mother because the child for child support is over 18 and in college.
Y esa es una moción que fue entablada de la madre, del menor en términos de manutención porque ya está en la universidad.
Sí.
Are you saying that you're still getting child support for her?
O sea, nos está dejando saber de que todavía recibe manutención para ella.
Sí,
Yes.
Is it for past child support or is it current?
¿Manutención que se debía o le siguen cobrando mensualmente?
bueno, me sigue llegando de la corte, pero yo pensé que al cumplir los 18 años se les quita, por eso lo estoy haciendo ahorita, que ya se lo corten.
I keep getting it through the court. I mean, I keep getting it, but I thought when she turned 18, it was going to go away.
Well, you still also have one other child too, right?
Pero todavía tiene otra menor, ¿verdad?
Sí, a ella no se lo quiero retirar, nada más a la mayor.
I don't want to take away from the youngest one, just with the oldest one.
Okay. I understand that. And I will terminate child support for Emily.
Y voy a terminar entonces manutención de Emily.
Oh.
Okay, gracias.
Well, they should be ordered
Bless
to the
her.
friend of the court to immediately stop.
Entonces les voy a mandar la orden directamente a frente del court para que inmediatamente ya se lo detengan.
I can't believe this.
So the child support then, the
Milagro.
amount, I guess, would be 639 now because it was 800 when Emily was on.
Ahora la cantidad va a ser 639 porque cuando era con Emily eran 800.
No, nunca me
No.
llegaba 800, me llegaban 649.
I never got 800. I will get 649.
Well, that's child support for one child is $639.
$639 es por un menor.
Ok, porque lo que tengo entendido me daban 2 cheques por mes de 349 cada uno, cada cheque, eran 2 al mes, 349 cada cheque.
The checks that I will get every month, I will be 2 checks that I will receive, and each one will be 339.
I don't know. I don't know if some of that's for past child support. Was the father in arrears?
No sé si si estaba pagando en términos de manutención de retrasos que todavía debía del pasado.
No, él nunca ha debido nada, me ha dado todo.
No.
Seriously.
He's always been up to date.
All right. I will issue an order that eliminates Emily from child support.
Voy entonces a preparar una orden que elimina Emily de manutención. ¿Está
I
bien?
will call it straight.
And according to the November 16, 2021 order,
Y según de la orden 2021,
child support should be $639 for your one child, Jack.
debería de recibir $639 por una menor, que es Jacqueline.
All right.
¿Está bien?
Good luck.
Buena suerte.
Thank you very much.
Gracias. Thank you.
Thank you, Mr. Romero. Have a good weekend.
You too. Have a great week.
There we
Eso no
go.
es verdad lo que me están diciendo.
A mí sí me estaban chingando, tío, que me estaban chingando más de 1,000, como 500 o más por cada uno.
That woman petitioned to terminate child support for her oldest child. I don't believe it. Only on Law Talk with Mike. You'll never see it again. God bless her. My guess is they still have a relationship.
Can you hear me? Are you Mr. McBride?
Yes, sir. I can hear you just fine.
Ms. Barnes, can you hear me?
Yes, I can hear you.
All right, this is case 10-11738DS, Barnes v. McBride. Both parties are present via Zoom. They have a child in common by the name of Kenneth. This is father's motion to enforce parenting time and legal custody. He says that mom has taken Kenneth and moved to Arizona. Well, she moved to Arizona and according to the defendant, he sent the child down there over Christmas and has not had the return of the child. Is that true, ma'am?
It is. That was a double rainbow.
The truth is, Kenneth was supposed to come with me August 1st. Kenneth has took my child twice. Plane tickets have been bought and he will not return them. We had a verbal agreement that Kenneth will go to school with me and come and see him every spring break, summer break, Christmas, and Thanksgiving. He took my child and said he wasn't sending him. My child said he wanted to come out for Christmas break. When he came down here, he said he didn't want to go back. He wanted to stay with me. And
Right.
I have the proof that he took my child every single time and ran off with him when plane tickets were bought. And he had me thinking he was going to take my child and he never bought him.
No, Kenneth
All
never
right,
won.
we have a custody order from actually 2011, that gave initial
Yes.
custody to mother.
Yes.
Nothing is stated anywhere about joint legal custody as this point. There's nothing in there. On 2014, in 2014, I believe it stated that the parties had been back together for some period of time. I don't know what, but there was a parenting order on 4/28/21 that father was to receive every other weekend and 2 evenings per week. There was another parenting plan
Yes.
in 2021 that dealt with holidays. And then father made another motion for parenting time in 2023 that was denied.
Yes.
But here's the problem is he's entitled to parenting time every other weekend, which is impossible to do from Arizona, but he's entitled to it. What are we supposed to do with this?
Because me and Kenneth had a verbal agreement. When I came down here May 27th, we made a verbal agreement. We spoke on the phone. He agreed to every spring break, every summer break, every Thanksgiving, every Christmas, any holiday longer than 7 days. He agreed to that. We had a verbal agreement. We didn't go through the courts. We had a verbal agreement and he agreed to it.
I'm just asking you, how do I enforce a verbal agreement if he says no, he didn't?
I can show proof.
You can show a verbal agreement?
I can show proof, the text messages and everything. Yes, he agreed to that. I have the proof.
You have text messages that he agreed to it?
Yes, through Messenger. Yes.
Something written, because I can't agree to a verbal one.
I would like to see that myself.
Now we spoke in person and we spoke on the internet.
We had talked about it, and when I talked to Kenneth didn't want to move down there. He just wanted to visit. And then when we told
me that
mom
he never
about that,
told you
she
that.
said,
one at a time.
and when we talked to mom about it, she said, "No, you're not staying there. You're moving up here with me." But he's like, "Mom, but I have everything too. But Mom, I really want to stay here." He even screenshotted and sent me messages with him asking her, "Can he just stay here?" And she kept telling him, "No, he have to move up there with her."
And why did he screenshot them to you? Why did he
'Cause I asked
screenshot
him
them to you? He
I
told me the
asked him
same thing
to.
because you were threatening him. Because you
I
were
never
threatening him and you
threatened
was
my
yelling at
son.
him.
Timothy,
That's why.
stop this, please. Stop
Okay.
this, please. I
We
never
can't even
Okay. Well, can we
record
have
any.
somebody
Hold
speak to
on.
Kenneth? Somebody needs to speak to my
Nobody,
son.
if everybody's talking at the same time, it doesn't make any sense. The bottom line is this: mother has physical custody. There's no determination of legal custody. However, generally, it is determined that you can't leave the state without permission of either the defendant or the court. However, because she has sole legal custody, or legal custody has never been determined, I should say, you almost have to have a hearing to be able to move to Arizona with the child, to move the child to Arizona. Now, obviously, I could have a hearing, and if she can show me all kinds of text messages or something that says, yes, she can go there and take Kenneth, well, that sounds to me like an agreement on your part, sir. If she doesn't, then
I have that.
Then Kenneth probably needs, how old is Kenneth?
14.
He's 14.
How long has he been down there then, ma'am?
He's been down here since December during Christmas break.
So
he was supposed to come. He was enrolled, but Kenneth gave paperwork to the school and they won't transfer over his paperwork. So now they won't even accept him because he gave court paperwork. So now they waiting for his IEP and other information until he can go to Anderson middle school. They won't accept him because he gave paperwork stating about court. So they told me I have to wait till court to even get him in school.
So Kenneth's not even enrolled in school down there?
He's enrolled, yes. He is. They have all his information, but Alger is telling me they won't transfer any of his information because his dad gave court paperwork about about custody hearing. So they won't transfer his IEP or any other information. But Anderson down here has all his information and they're ready to enroll him. But because of Kenneth doing whatever he did with the paperwork, Alger won't send over none of his information.
Bottom line is your son is not attending school.
He's not. He's enrolled, but they won't send over none of his paperwork because of the situation. He's enrolled, but he hasn't been because Alger won't send over his paperwork.
All right, Mr. McBride, what have you got to say? Do not interrupt him, Miss Barnes.
Like I was saying, sir, we talked about it, and I said I'm gonna talk to Kenneth about it. Kenneth didn't want to move down there. He wanted to stay here with me. let me talk, please. Kenneth wanted to stay here with me, so I made, because he's 14, I let him make a decision of his own. I'm not gonna force my son to move somewhere out of state. And I asked Tamika plenty of times, can I please get an address? If I'm sending my son out of state, can I get an address? She will not give me an address. I got an address. It was a fake address. We mailed the letter off, which is this letter right here, and it came back in the mail because you gave me a fake address. So I like,
You
that's why I
put
was
down
like,
the wrong information.
I felt like I didn't want to send my son for that reason right there, because I don't want to send my
No.
son out of state where I don't know where nothing with him whatsoever. I don't know if he's in good harm, nothing. Me and her baby daddy had bad terms. I don't even know if my son in good hands down there like that. Tamika can't keep a house for a long period of time here. She kept getting evicted.
All right,
Out
hold
of
on.
every other house she been in, I don't feel
Excuse me,
comfortable with my
Judge,
son
he
down
put
there.
down 685. My mailing address is 683. I screenshotted him yesterday and told him he sent the wrong address. He knew what he was doing. I gave him a
No, I
mailing address
didn't.
due to the fact that he always calls CPS and the police at every single house that I have every time he
I
get
never
mad.
caused
My
them.
baby daddy, no, let me talk. My baby daddy has nothing to do with anything. If that's the case, I could bring up the fact that your girlfriend told me not to send my son back because you can't take care of him and you don't have a house to live in because she don't want you there. So we're not talking about that. We're not talking about that. Talk about you and talk about how you told me that you agreed to everything and then you went back and denied it and then had your girlfriend run off with my son when my mama came to pick him up. And you told him you ain't know where he was at. So stop with the lies, because all this is lies. Stop it. You agreed to it. We can go on the trial, we can go wherever. I got all the proof that you agreed
Ms.
to it.
Barnes,
So we can
I've
take
heard
it there.
enough now from you. I asked to hear from Mr. McBride. I told you not to interrupt. I've heard from you. I'm just trying to get his side of the story. Mr. McBride, put your face on the camera.
Got worse.
I'm here, sir. It's just every time she yells and stuff, I just got to put the phone on because she does this all the time. I can't talk to her. So what I get all the time.
See
You
what I'm
guys,
putting
we
up
can't
with,
even
Judge?
have an adult conversation with to even come to any type of agreement with him.
Have you filed any kind of complaint with the friend of the court for missing the parenting time?
Yes, I have. That's why we're in court right now. That's why we're going through this right
No,
now.
that's not why we're in court, because you filed a motion. Anytime that you were ordered to have parenting time every other weekend and 2 evenings a week, okay? And if you're not getting it, because mom, you need to file a complaint with the friend of the court, because then they will determine what's going on, and I may hold Ms. Barnes in contempt if she's not allowing that parenting time. In the meantime, I'm gonna have to set up some kind of a evidentiary hearing to determine, I guess where Kenneth should live in this matter, because I don't know. I don't know why Kenneth wants to be with you or with her. I have no idea. And this
Is there any way that anybody could speak to him?
It's gone on for a long time, and I'm gonna have to have some kind of evidentiary hearing regarding, I guess regarding custody. To make a
That's fine with him, sir.
determination, because there is no legal custody determination will include physical and legal custody. You both will get notices of it, ma'am. I always have my hearings in court, but you're living in Arizona, correct?
Yes.
All right. If you want, and I assume you want, I will probably let you participate via Zoom as opposed to flying up here. All right?
Okay.
But you're still gonna have to follow the other stuff, like if you have evidence, like supposedly, statements through text and what that he has made, you're gonna have to make copies of them. You're gonna have to give copies to Mr. McBride, because before you introduce them or before I read them, he's gotta see them. All right?
That's fine.
If you don't do that, I will not look at it and will not consider it as evidence.
That's perfectly fine.
All right, so we'll send out notice to both of you. At some point, I'm gonna also talk to Kenneth, because I don't know where he wants to be. All right?
I wanted you to do that last time, Judge, to be honest with you.
You want what?
I wanted you to talk to Kenneth the last time we had our hearing, because I'd rather for him to explain where he rather be at and how he feel comfortable, instead of me and mom just study fussing and arguing back and forth over the phones.
I understand, but it's the facts of life. You guys can't get along, so I'm gonna have to make a determination whether Kenneth should live in Arizona or
That's
here.
fine.
And if he lives in Arizona, what kind of time does he get? If he lives here, what kind of time does mom get?
Okay.
That's the way it's gotta be. And
That's
this
fine
won't
with
be
me,
in the
sir.
next couple of weeks, but I'll get you on as soon as I can. Make sure you look at the notice and send in the appropriate information, or I will not have it here, okay? Ma'am, you're gonna have to make copies and send stuff in so that I can have it, if you will, all right? Unless you plan.
I
on
will.
doing
That's
it.
no problem.
All right, all right. But you must send copies to Mr. McBride. If he doesn't get those, you
Oh,
know,
he'll get them.
and.
And
Mr.
also,
And let Mr. McBride talk to his son out there.
he does. He talks to his son all the time. His son has a phone.
Oh, all right. All right,
Is there any way you could get him to release my son to go to school while the time that he's here, so he don't be out of school until we're going through this?
Mr. McBride, get him
Yes,
in
sir.
school. Get him in school. I'm gonna make a determination where he's gonna be, but don't have him sit out of school for a month, 2 months, 3 months, whatever it is, until we can figure this out.
Thank you.
Okay.
You're gonna do that?
Yes, sir. I'm gonna call the school. I told the school as soon as we got off the phone, like when I got done with the court and everything, I was gonna call them and let them know what to do with the school records.
Please do that, because otherwise you're only hurting your son.
I know. I will do that.
All right, good luck, everyone. We'll send you notice.
He's a reasonable dad. She's not the worst either. She's jacked up, but she's not the worst I've ever seen. But he is definitely a reasonable guy.
I understand we have Emily watching here today. Morning, Emily. How are you? All right, Mr. Carlson, Miss Carlson, welcome back. Haven't seen you in a couple weeks.
Yes, Your Honor. Thank you.
Miss Carlson, can you hear me?
Yes.
I think I have this. I think we rescheduled this motion to make sure that everything got done on that timeshare. Is it done?
Your Honor, I do have an update on January 11. The timeshare, the title company sent both Ms. Carlson and I an email with documents
Fortunately, yes,
attached.
I have.
On January 17, I had that information, my part of it, notarized and sent it back priority mail. As of yesterday, January 25, I called to verify that they had received all the information, and they have received everything except Ms. Carlson's information at this point.
What is the information? I mean, her driver's license? and stuff?
No, she has to have the documentation notarized as well, and they sent us each a.
Are they seriously fighting over
format,
timeshare?
and I bring in a portion and have notarized. She also needs to bring in some information and have notarized indicating that she is in agreement to have her name pulled off. And then it goes to court in Florida for a, I believe they call it, it's a quick claim deed, I believe they called it. So we're just waiting right now to
Of course, it's someone
get her information down
away
there,
from
and then they can send it to court and go from there.
Those are
Ms.
just horrible
Carlson?
liabilities.
It was shipped on Friday, January 19th, and I have the receipts of that right here. And the cost of it was $31.53 in order to do that, because I had to have it notarized as well and witnessed. So it was done. I have both receipts verifying that it was shipped.
All right.
Do those receipts show if it was received yet, or?
No, just shows that they were shipped.
Because I know it took about 5 days for mine to make it down there, and that was even sending it priority mail.
Yeah. I can't believe we even have to
All
say
right.
this.
Then it sounds like everybody's done what they're supposed to. If you sent yours on the 19th, ma'am, where are we, the 26th? They should have it now, it would seem, and things should be proceeding. Stay in touch with the people down there to make sure that it gets done. I really can't control what they do. Okay. I can't do that much with it. But make sure everything is done. If there's any other requests, you must take care of it promptly. Other than that, it appears that we're moving along towards getting that taken care of.
Yes, Your Honor, the title company, when I spoke to her, said once everything's there, it's about a 45 to 60 day wait for it to go through the court system and get the quit claim deed.
All right, ma'am, what do you have to say?
That's all fine. I mean, I know I've sent my piece in. Now I'm just waiting to hear back from them. But I am asking for reimbursement because I've had to take so many half days off of work. Mr. Carlson does not work. I work 2 jobs and I can't afford to keep doing this. And I've had to do it several times in light of last February. And I would like to get reimbursement for that, including today, which is another $150 with a total of $810 reimbursement.
I mean,
For this
as I recall, last time you were asking for parking fees and all kinds of stuff.
Yep.
that
All
were-
related to
That were
this.
outrageous, I'll just say that, okay?
Okay, well, at least my time off work isn't outrageous.
I don't know why, you're telling me you gotta take time off work, you're on Zoom.
No, I have to go down to the court, file a motion. I have to go down to the court to pick up motion paperwork. There are 4 times I've had to go to the court. And I had to go down, pardon?
You got lunchtime, you got after work, you got.
I don't, no, I don't. I work from 7:30 AM to sometimes 8 PM. I don't have that flexibility.
Every day?
Every day.
I'm gonna respectfully deny your request at this point.
Okay, that'd be a no.
At it at that time.
Well, how do I file another motion then to have that relooked at? Because I don't agree with that.
That's all right, I'll issue an
That's fair.
order and it'll say on there, all right? It'll
Okay.
say on there, if you wish to appeal it, you can appeal it to Judge Hillary and determine if he wants to do that.
Okay.
No vote, which will make you take more time off, which will of course be at your time.
Correct.
So I'm gonna respectfully deny it at this point. Good luck, everyone. Hope it gets taken care of.
I still have another motion to enforce the equalization of our pensions that I was unable to do all these years because I didn't have the financial resources. And I have to pay half of that, and now I have that.
When was that motion?
I filed it, it was part of today.
Well, part of today, we set this up.
Then there was 3 other motions following. One was the PPO, which we dealt with that.
The judge already heard you guys this morning.
What?
Weren't you in front of the judge already this morning?
Yep, for the PPO and the sealed copies, and then we were sent over to you for the enforcement of equalization of educational pensions and the rest of the timeshare stuff.
The motion that I have. The last motion that I had that you sent in, ma'am, was for a hearing on, which I was 12/29. The motion was to enforce. Motion states, it says supplement to motion. All these. Which doesn't have anything in the supplement to motion.
So I have in front of me from your office, the Judge Frederick on 1/26/24, 8:30 AM, motion to enforce the equalization of educational pensions. And they were all signed and delivered. I had them hand delivered to Mr. Carlson, along with the PPO information.
Notice that went to you says motion to enforce, doesn't say anything about equalization or anything.
In the motion, it does.
In the motion that you filed when?
On,
I've got a supplemental motion that was filed on 12/15, refile motion to enforce name removal from timeshare in Orlando. Motion to enforce the order and all that kind of stuff. Doesn't say anything about equalization.
so there was a motion, the motion for the sealed reports and the motion for the equalization of pensions. They were also done at the same time as the resubmitted ones. I paid for them. I gave them, they did it at the clerk's office and they sent them out. Well, didn't send them out. I had to have them hand delivered. So I'm not sure why you don't have that. But it was to enforce the equalization of educational pensions, and I had limited funds my entire life.
When was that filed with the court?
Doesn't have a date. It just says the date that we're going is the 26th. Oh, it was filed 1/4/24.
Mr. Carlson, do you know what she's talking about?
Your Honor, I have it too. I was served basically a briefcase of papers with 4 separate motions in there. So I was not even sure who to go to and how to do this morning. In fact, I had to call your clerk to find out where I go first. I have that motion. I didn't know who was hearing it. I thought perhaps Judge Hillary was hearing it. Then he adjourned and we moved over to you.
And it was filed on 1/4 along
Yeah,
with.
their file down there. I believe the judge has that motion. And the clerk, I believe the judge has that motion. And I don't have it. And I don't know what, I just simply don't have it. And I believe the judge has it.
Your Honor, he set another motion for us in regards to the sealed documents on March 8th. Could that one just be moved over for March 8th then, and we'll just deal with that then with him? Or
I suppose, because I don't have it here, so I don't even know how to rule on it because I don't have anything in my file. The judge has things. I will check with the judge afterwards, and it's about equalization of
Pensions, the educational pensions.
equalization of pension. I'll find out because I don't have it.
There were drugs involved that were given to me that ended up.
Did you provide a judge? The clerk at Judge Hillary doesn't know anything about it. I don't know anything about it.
Well, I did it right there at the clerk's office. They filled out the paperwork, the form, and then I had them all.
And they filled out the form.
Correct, like the
What?
notice of hearing I did. And then I paid them the $20 for each one. And I have the receipts for those on the 4th.
But I don't know what did you file a motion?
I did file a motion. It says notice of hearing in motion.
That's a notice of hearing in motion. I don't care about that.
Well, that's what I have. That's what they gave me.
Well, I don't have it, so I can't rule on it. I'll see if the court has it anywhere somewhere. If we do, we'll contact you and set up a date and time. If not, I don't know what to tell you. I don't even know what you're talking about as far as them setting up a hearing or not. I don't know what your claim was in your motion. What did you write in your motion?
I wrote to, all I said was to enforce the equalization of educational pensions, that I've not been able to do this financially until this time, due to limited funds. So I asked for that to be now, because now I can pay half of it to get the funds equalized, because Mr. Carlson had more years at the time than I did, because I stayed home with kids and
Was
didn't
that
work.
something in your judgment?
Yes, it was part of the judgment of divorce.
We'll take a look and see if there's something out there, and if so, we'll set up a time. Good luck. I just don't have anything, so I can't rule on it.
Okay, so what should I do moving forward with that? Refile it?
If you say you already paid the fee, then I wouldn't make you pay the fee again. You'd have to refile it, but it'd just be a renotice, but I gotta find the motion itself that you sent in.
So it was on the 4th.
I don't know whether or not you just took the motion with you, maybe. I don't know.
Well, they gave me 2 copies, one for myself and one for Jeff, and then kept 2 copies for you guys, and stapled all the papers together at the clerk's office.
My clerk will look into it after we get done here today, but that's all I can do. I just
Okay.
don't have it. So, Mr. Carlson, do you know what you're talking about as far as equalization and stuff?
Yes, Your Honor, that was something that, and I can't remember which attorney she had at the time, but one of her attorneys brought that up. And I talked to my former attorney, Miss Rathburn, and she actually indicated that I guess the way that was written is that was Jean's responsibility to start that process.
Okay, but if she started it, then why don't you get this stuff done?
No, it was never started, Your Honor. The
So
process.
she's saying she started it now.
She started the motion. Yeah, I don't even know what to do with it at this point.
I don't know. We'll see what's going on and try and get you notice of what we need.
All right, I did get 2 names of people that do that equalization. One is a Jenny Johnson.
Yes.
And the other was through a corporation or company called, I believe it's Quadro Express.
Yep.
So the one that they put in our judgment was Miller, and I contacted them.
Miller.
Miller.
Law firm.
Yeah.
Miller Johnson, what?
Yes. That was what was in our judgment of divorce and that we were both supposed to pay half to have it equalized.
All right. So why don't you 2 figure out somehow a way to have it equalized and Jenny Johnson, I doubt you're gonna use Miller Johnson now because how old is that judgment?
That's about 17 years old, Your Honor. And what's going to make this more difficult is Judge Hillary signed a PPO, so I cannot have any communication with Ms. Carlson outside of
when does this
right
end?
here, obviously. So I, obviously can't violate a personal protection.
17 years with her. Holy.
All right.
Lord.
Well, I don't know what to tell you because all I'm gonna, even if I grant the motion, if I can find the motion, all I'm gonna do is say, yes, you gotta get to work and spend, each of you gotta do what you have to equalize it, go to a Quadro specialist to do something. I don't even know the pension, the 17 years old, who controls them and stuff like that.
It's controlled through the Teachers Association. It's
of course.
It's basically through Lansing.
All right, ma'am, why don't you make contact with them in Lansing and see what you gotta do?
Okay, I know that they need his information, so you will also have to call them because they need to know what his pension was at that time.
I have no idea what it was 17 years
That's
ago.
why you have to call them.
Well,
I'm pulling my hair
I
out.
guess I would give you the ability to text him the information that who he has to contact to start this process.
Okay.
And not find it to be a PPO violation. Your response isn't necessary because she's going to send it to you of who to contact to do this kind of stuff and to find out what it is. All right.
Sounds good, Your Honor.
And then just take it from there. All right.
All right.
Thank
Now,
you.
is your office still going to look for that motion and set
Yeah,
something
I'm
up?
still gonna look for it, but there's no reason that the 2 of you can't get it started because ma'am, what am I gonna order? Yes.
Well, just the fact that it needs to get done, and I have the ability to now start this process.
And
Get
what
it
I
done.
don't do is I don't issue an order to follow an order. If it was a prior order, you gotta follow it.
Well, it was just to have it enforced,
All right.
but you don't have it, so I'll just work on my end and get it rolling.
And like I say,
Why would
you
the
can
order?
text him the information because otherwise he's gonna come in and say, I don't know. And I'm gonna
Right.
say, okay, then give him the information.
Exactly.
Well, I will email him the information.
Email him information. Sir, you don't have to respond to it because you got a PPO.
True.
right.
Now, okay, I'll
right.
I'll wait to hear something one way or another.
All right, good luck, everybody. We'll.
All right,
get
thank
back
you.
soon. Thank you.
Bye-bye.
Jump on his meter. Shut up. Jump on his meter. Jump on his meter. Shut up. Jump on his meter. Jump on his meter. Shut up.
Can you just let this go for once? Okay, back to the
Jarrett, can you hear me?
Yes, sir.
All right, we're waiting for Miss Fitz to connect. Wonder if Sharon's watching us here today. In San Diego. If so, hello.
Ma'am, are you a whore? You're not a whore? Not a whore?
This is the best for filling gaps. It's always applicable.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Let's go. You didn't say the cat jumped on his wiener, did you?
Ready to go?
Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
Just leave them on and we'll
Can you just let
mute
this
them and
go
I'll take
for
another
one?
one.
For one.
So I'm gonna mute you for right now. You can stay on the screen if you want. Miss Fitz is not connecting. I'll leave her on the screen, and if she connects, we'll tell her to mute. I'm gonna take another case in the meantime while we wait for her.
Yes, sir.
Mr. Sharts. Not a whore? Mr. Sharts. Mr. Sharts. Mr. Sharts.
Mr. Gordon, can you hear me all right?
Yes, Your Honor, thank you.
Thank you. Good morning. Miss Schmidt, can you hear me all right?
I can, Your Honor, thank you.
All right, we have Heather House. Miss House, can you
Yes.
hear me?
Yes.
Ms. Fritz, we've been waiting for you to connect. Please mute for right now. You'll be the next case that we take.
Okay, thank you.
If you can hear me, Ms. Fritz? We're gonna take the House case first. Ms. Fritz, please mute for right now because we've been waiting for you to get on. We're in the middle of another case first. You'll be
I'm
next. So just mute and
I love it.
turn your camera so you're not laying down.
Late, muted, and sideways.
Okay, you please mute yourself there.
I'm trying.
Fantastic. It's the
All right,
trifecta.
this is a matter of House v. House, case 21-10925DM. Both parties are present via Zoom. Other House, you just kind of vanished. Are you still there?
Yes, I'm here.
All right, you have a camera?
Yeah, it's not working currently. I was trying to get it to start.
All right, well, everybody acknowledges this is her, I take it, so I can proceed. As I say, both parties are present via Zoom. We have Ms. Schmidt representing the plaintiff, Ms. House, Mr. Gordon representing the defendant, Mr. House. This is a motion filed by the defendant, Mr. Gordon, for specific parenting time. There was a judgment of divorce from 6/2/22. The parenting time was as agreed between the parties. Apparently, Mr. House has moved to Indiana and seeks a specific parenting time, which I must hear. I mean, I have to have a hearing or something regarding specific parenting time when requested. Is there any, I mean, have the parties, you, Mr. Gordon and Ms. Schmidt talked about some way of dealing with this or something?
No, Your Honor. I mean, from me reading their response, I think what they would like to do is to go to the front of the court. And I think what she's proposing is that Mr. House have some parenting time during the interim here in Michigan. We of course would want him to be able.
Where does he live?
I'm sorry?
Where does he live? Indiana's a big state.
He lives in Indiana on the north part. He actually has another child in Elkhart, Indiana, and he has alternating weekends overnight with that child. So
Like, How far does he live from Grand Rapids? I mean,
So halfway, Your Honor, would be Kalamazoo.
well, then Mr. House, you must live just inside the Indiana border.
Yes.
All right.
He likes to wander Indiana.
All right, and so both parties want to, it also requests for mediation. I think both parties have requested mediation or friend of the court.
Yeah, I mean, from my perspective, Your Honor, and I agree with what you stated. Under the law, the court has to order some sort of specific parenting time schedule. And so my thought would be either we have a evidentiary hearing scheduled with Your Honor, or we refer it to the friend of the court. And then what I would want to do is to try mediation in the interim with an agreement that Mr. House does get at least alternating weekends here in Michigan so he can see the children. And then also at least one or two evenings, he does work until 5 or 6, where he can call the children, because that has been an issue. And I think one of the big reasons that he hired me is he can't work it out with her, and he can't even speak with his children.
Okay,
And so
can
as
I
long as
ask,
we have
can I
something
ask this
ordered, he can do
question?
it.
The response says he works 6 days a week, so he doesn't have the time.
He does that.
Mr. House, can you in the interim come up to Grand Rapids and see your kids for the weekend?
Yes.
Then Ms. Schmidt, I can't think of any reason why he shouldn't have that. Can you?
No, as long as it's here in Grand Rapids until, as Mr. Gordon said, we either go to front of the court, and I am also amenable to mediation.
I think you should try mediation. I mean, you guys both do that kind of stuff, and can you agree on a mediator?
Sure. Yes.
Any hints on who you'd like, so that if we can agree here or something?
I like Mr.
Well,
Dantima.
I think Mary Benedict does a very good job. She's reasonably priced, and she gets to the point. So I don't know about.
Ms. Schmidt has suggested Mike Dantima. Do you?
I like Mike Dantima too.
I think he does a good job with these types of cases.
Yeah, Mike's a good sort.
Can you guys agree on that here, and we could just get it? I'd like to get it going. Okay. I mean, I want to move this case along. Clearly, Dad's going to have parenting time. Clearly, he doesn't. I mean, it's not like he lives in Indiana, or excuse me, Indianapolis, where it's a 5-hour trip.
Oh no, he lives in Indiana, Judge.
Yeah, he could live in Cadillac, and it'd be just as close as that would be. So he's going to get some time, and probably something like every other weekend and things like that is what I would look at. But for the time being right now, we can agree that he will have every other weekend from, I don't know what time he can get here.
Well, my understanding is it's a 3-hour drive, 2.5 to 3-hour drive from his house to Grand Rapids.
So what? He's got to make it.
Okay.
Right. I mean, it's not that big a deal. I have plenty of people who travel from Traverse City or more to and see their kids. Okay. So it's not that huge a deal, but he has agreed that he'll come up every other weekend. When would you be here, Mr. House, or where, Mr. Gordon, do you know where he would stay with the kids?
Well, generally he gets a hotel, and so he has been exercising time up until there was a financial disagreement, and then I think he got cut off. So he's actually had the children at his residence in Indiana, and as I mentioned, he does have overnights with his other child. He has not had overnights with the girls in this case in Indiana, but he has had them. They have seen their bedroom. It is appropriate. And
Mr. House, when can you get the kids is what I'm asking, because if you're working Friday and you do have several hours or something like that, I'd like to work something out. Quite honestly, what I'd like to do and what I'm going to order is every other weekend you can have them from whatever start time. I don't know when the start time should be, and I'm going to suggest, and I'm going to order that every other one of those can be exercised in Indiana until we get to someplace. Okay, so you'll come up this next time that you get parenting time, you're going to come up and exercise it in Grand Rapids. The next time you're going to exercise it, but you're going to have to do the travel in Indiana.
Okay.
What time are you looking at? I mean, what time do you get off work?
So I have Fridays off. I work Saturdays from 9 to 5 and I have Sundays off.
Who's gonna watch the kids while you're working?
My grandparents,
That live there?
yeah, they live here.
Well, Your Honor, these children don't know any of his family. They have never met his parents. In fact, it was my understanding from my client that he doesn't even have much of a relationship with them. They have never met his parents, the grandparents.
Would you rather the kids be in daycare?
Miss House?
I mean, it's
Um,
ridiculous.
There's not available on Saturdays, so I'm not very sure how that would work, but my children have no relationship with his parents, so it would be dropping them off with strangers, which is not an
Question
ideal.
was, Miss House, the question was, do you prefer daycare?
Yes,
Drop them off with strangers?
Well, hold on, Your Honor. My understanding is the children have met their grandparents.
Look at that.
So that's just not even accurate at
Hold on.
all. It's
No,
just,
hold on. I've got this under control, okay? I mean, strangers are strangers. Daycare are strangers, all right? And I have no reason to believe that his parents are going to, serve up the children for dinner. So I'm gonna go with it at this point. That's gonna be my order. You can do something, you can appeal it if you want, but and then you're gonna go to Mike Dantema for this matter.
Yes.
Yes.
And
What is the start time on his Friday here in Michigan?
not till next Friday. That'll
No.
be his first one.
Okay, what time?
Mr. House, what time? How are you gonna work it out if you gotta have the weekend up here and you work Saturday?
What do you mean?
Well, you got a weekend, next weekend, you can have the kids here in Grand Rapids,
Okay.
all right? When are you gonna get them?
I can get them on Fridays.
All right, but the kids go to school, so Friday at 4 o'clock?
Yeah, whenever they get off, yeah.
Are they available by 4 o'clock, ma'am?
school dismisses at 4.
All right, 5 o'clock, you'll have the kids from 5 o'clock till 5 o'clock on Sunday. Now, what are you gonna do with work that you gotta work on Saturday? I don't care, you get the kids, okay?
Okay.
And then 2 weeks later, you'll have the kids in Indiana for the weekend. Your parents will act as daycare providers, okay? You only work during the day, so it's not. All right?
Yep.
And then the parties are going, and then the next 2 weeks later, you'll have them up here until we can figure this out, all right?
Okay.
You must notify mother where you are. Okay? You understand that? I mean, if you're getting a room at the Holiday Inn, she's got a right to know where you're going to be with the kid. All right?
Okay. Yep.
Must inform her ahead of time, I'm gonna be staying at such and such a place. All right?
Okay.
And I assume that he's allowed to contact the kids every Tuesday and Thursday or something. We can do that via phone or FaceTime or something at 7 o'clock.
Thank you.
Okay,
All right?
and Dad's doing the traveling.
Dad's doing the traveling right now,
Okay. Meeting at her house?
I suppose. That may change when you guys mediate it or when I have an evidentiary hearing about it, but
Sure.
right now, since he's got to make the trip anyhow to be here in Grand Rapids, he can make sorry, sir, but you can make the trip. All right?
Yep.
Dropping him off 5 o'clock till 5 o'clock is the time on the weekends. One of them is here, one of them is down there, one of them is back here until we get there. Mediation with Mike Dantema. Should I would just soon wait, but then that'll push you farther out. If do I need to set a parenting time evidentiary hearing, or should I wait until Mr. Dantema sees if he can figure it out?
Well, Your Honor, given the court docket, and I understand you are swamped, I would prefer that we get a date on the docket. But
It's
I
not gonna
can,
be early, and if you guys figure this out and you don't contact me immediately to get rid of that date, you will go on the really bad list. Okay?
I promise you, well, number one, I think we're gonna resolve this case with your help, with what you ordered today. I think we're gonna get somewhere. And so we will notify the court immediately. I don't want to waste your docket at all.
Yeah, because I want you both to get into Mr. Dantum and tell him it's kind of in a hurry because you got a time slot.
Yes,
And
absolutely.
like I say, if you get close to it and you haven't, and you go, oh yeah, we just settled it, you will go on the naughty list and you will be late.
I'm gonna let you know immediately. I promise you, Your Honor. I promise you.
All right.
I've been on your naughty
agree
list,
with
by
that?
the way. So
What?
He is charming as hell.
What's that?
I said I've been on the naughty list. I think I've been taken off the naughty list, but I'm not
Off the
100%.
naughty list. I don't have any problem with you.
I've spent some time on the
Your
naughty list.
subject going back on it, just a heartbeat. Okay.
Your Honor, I
Yes.
also have one other concern is that while Mr. House is transporting these children, he must use appropriate restraints at all times.
Absolutely. Absolutely.
No
You must
seeing the
have
kids on his
whatever-
lap.
I
or the
understand,
girlfriends.
and absolutely, if you're not using whatever the appropriate seat is or something, and somehow somebody finds out, you're gonna lose a lot of your rights to that.
Okay.
Talk to Mr. Gordon about it. Don't mess around with this kind of stuff. All right?
Yep.
Anything else, Ms. Schmidt?
No, Your Honor, thank you.
Mr. Gordon?
No, Your Honor, thank you.
Mr. Gordon, you can draft the order since it's your motion, get it and send it to Ms. Schmidt. Okay?
Okay, thank you, Your Honor.
Good luck, everyone. Thank you. Have a good weekend. Take care.
Thank you.
Thank you.
Oh yeah, there's a link to it in the description. Now that it's all stuck in your head.
All right. Hopefully Fitz and Jarrett. All right. Can you both hear me now?
Yes, sir.
Ms. Fritz, you're on mute. So thank you for going on it, but now you gotta get off. Whoa, can you hear me at all? Oh, there you
Yeah,
go.
I can hear you. Sorry.
Case 14-1091 DS Fritz v. Jarrett. Both parties are present via Zoom. This is regarding Braylon, who I think is 12. This is Dad's motion regarding custody. He's been, well, let me go back. 2017, there was a judge, there was an order that gave Mom legal and physical custody and father supervised parenting time. Father was in Tennessee, I believe. On 10 of 21, there was a stipulated order that he did not need to be supervised anymore. He would have a majority of the summer down with Dad in Tennessee. We're at this point now where father has filed a custody motion saying that he's returned from Tennessee and now wants 50-50. That pretty much states what your motion says, sir. Is that correct?
Yes, sir.
All right, well, ma'am, I don't know what your thoughts are on this, but quite frankly, to change custody as you're requesting, you need to meet the principles found in a case called Vidvarka, which means there has to be a change of circumstance or proper cause. You moving from back here is not a change of circumstance that could have a substantial effect on the child's life. It has an effect on your life, but you want to change custody to 50-50, and quite frankly, you don't meet the Vidvarka standard to get 50-50 at this point. However, I guess I would agree that we got to figure out something regarding parenting time, because you're living back here and it doesn't make any sense to give you the summer as if you're in Tennessee. Anything you want to say, sir?
Yes, I'm willing to do whatever type of order it takes for me to get 50-50. Braylon is my only child.
It's not a question of do anything you want to get 50-50. There's an established custodial environment with mother, and you have to meet Vidvarka, which means a change of circumstance or proper cause, and you just don't have it at this point.
Correct. So meaning, I filed this motion just so the court could just know and understand that I'm willing and I'm trying to take the steps to be able to take care of my son basically half of the time. I understand that it might take some proceedings to get the physical joint legal part of it, but as far as me spending time with him, I'm just filing this motion so I can get as much time as possible with my child.
What is your current parenting time with the child?
I believe it was just set up for summer times.
All right.
Like some
Let me
random
ask Ms.
holidays.
Fritz. Ms. Fritz,
Yes, yes.
he's back and I mean, the last order basically gave him a big chunk of the summer in Tennessee. I think there was like a July 14th, somewhere around there. He came back for a while and then went back down there. Isn't that correct? I'm just going on memory. So.
That's what our order was, yes, but that's not how it played out.
All right. Well, he's back. And what are you suggesting he should have his parenting time? Because it's a clearly different situation. There's no reason.
I think at the current time, every other weekend would be appropriate with, he could do one one overnight during off weeks.
Okay. And that sounds pretty reasonable at this point. Friday to Sunday, whatever that, 6 o'clock till 6 o'clock Friday until 6 o'clock Sunday. Does that work?
Yes.
Sir?
No.
What doesn't work about it?
I would like every weekend because I'm back in town.
You're not going to get it. I'm not going to order that.
Okay. I want as much time as possible, but I do not.
I understand, but there are also certain things that you have to go through that you just are saying, I want more time, but that isn't the way this works. There has to be legal standards that are met, okay?
I apologize, and I'm trying to do those legal standards. So whatever you want to order for now, I'll accept because I'm not getting any time. And then if I have to follow other proceedings to get whatever else is needed, I will do so, sir.
Friday from 6 o'clock, does that work? Good time for you, ma'am?
Yes, sir.
Friday 6 to Sunday at 6. And if he's not going to start that till next weekend, unless you want him to start it this weekend, but you haven't had any time to prepare for anything. So I will, if you would, do you want to start this weekend or next weekend, ma'am?
Next weekend will be fine.
If I could interject.
Yes.
When I originally came back, I came back in like October. We were getting every weekend. And basically because I asked for more time, that's when this whole proceeding started. She told me she wanted me to go file for custody. So that's why I'm filing. So if it could be for the judge, if you could allow it, I'm actually ready for him this weekend. I haven't seen him since January 8th, since all of this has kind of gone down. So I personally would love to see my son this weekend because I haven't been spending any time with him.
It will be every other weekend, Friday at 6 till Sunday at 6. It will start next weekend. We'll also have, you said, ma'am, the off week. I don't know what the off week is, because if he has this coming Wednesday, is that the off week or is next week? Because then that's the one I'm going to, normal parenting, as far as I'm concerned, he would have every Wednesday night overnight. From 6
I could agree to every Wednesday.
From 6 o'clock, and then he'll take him to school on Thursday morning.
Okay.
Is that any problem?
Nope.
Wait a minute. Wednesday, what time does your son get out of school?
He gets out of school at 2:30.
All right, well, then we're gonna start it.
Agreed.
Wednesday, he can have him. Sir, are you working or anything?
Yes, sir.
What time can you pick him up?
2:30, right after school.
Well,
He would need to go home first and get his belongings.
I'll let him, I'll let you start at 4. Now, I gave you 6, I'm gonna back it up to 4. Wednesday at 4, until Thursday at school. All right, where you will be responsible to get him to school. You better get him to school on time. And work with them for homework and all that kind of stuff. That's part of being a parent. So it'll be every Wednesday from 4.
May I interject again?
What?
So I'm actually filing this motion so I can have 50-50 with my child. I understand how it looks.
Going to get it.
Yes, I understand that. My question is, what are the proceedings for me? That was going to be my question. How can I obtain that now that I am back and I'm
Need an
here?
attorney.
You have to
and I'm
meet Vidvarka and you don't have any Vidvarka.
where would I
Go to an
receive that
attorney. I
information?
can't give you advice. I can't give you legal advice because that's like saying, here, you do this, mom. Then I tell her, here's what you do to defeat what he wants to do. Okay? I'm not there. Go to an attorney.
I understand, sir. I'm not trying to come off any type of way. I'm simply asking a question. So if I want more time, can I try to schedule a mediation with you right now?
Yeah, I'm not, no. I'm not a mediator.
I'm asking with this current parenting time order that we're setting up, would I be able to have a mediation to receive more time?
Yep.
You can do whatever you want. You
That's
go
the
to an
vibe I
attorney
get.
and figure it out, but this is the time you've got now. All right. We'll get that order out Wednesday, 4 p.m. to Thursday morning at school. If he's not at school, it'll be like 9 o'clock in the morning is your return. You understand that?
Yes, Wednesdays, if he's not in school, return him by 9 a.m.
Yes, otherwise, and it'll be next Friday. It will be this Wednesday at 4 o'clock is the first thing to start.
Correct.
Next, and then you will have every other week. Thank you very much. Good luck. Thank you.
Thank
ma'am.
you.
I have one more question.
What?
How should we exercise the picking up? Should Brandon pick him up from me or I drop him off or?
What we should do, first of all, on Thursdays, he's gonna drop him off at school, okay?
Yeah, for
Other
Wednesday
than
for
that-
pickup.
Other than that, the party who is getting the child will be responsible to pick up the child, okay?
Okay,
So when
thank
he
you.
gets him on Friday night, he's gonna pick him up from your place. When you get the child back on Sunday, you'll pick him up from his place. Wednesday, he'll pick him up from yours. Thursday, he'll drop him off at school,
Okay, thank you.
all right? All right,
So, Your Honor,
what?
I'm picking him up from school on Thursdays, I assume, because
You're not picking him up from school on Thursdays, you're picking him up on Wednesday from mom's house at 4 o'clock.
right. So the way that it was before in the past, mom's usually at work. I would have to go through a grandparent. I'm just trying to get it understood.
I don't work
that,
on Wednesdays.
She doesn't work on Wednesdays.
okay, so me or my mother will be picking him up from her house on Wednesdays, 4 p.m. Got it.
Good luck, everyone. Thank you.
Thank
We'll
you.
send you the order.
Thank you.
Yeah. He's hard to like. She's reasonable and just
What is this one, 13? Is that what you said?
just lamenting
Yes.
that decision every time she
Number
sees his
9.
face.
Oh.
Andrew. Meds haven't kicked in yet, Andrew?
All right. You're both attorneys. Ms. Coletti, can you hear me?
I can, thank you.
All right, we have Ms. Hutchinson, we
Yep.
have Mr. Ferentz is logging in, and we have attorney, and I'm sorry, is it Diab?
Correct. Good morning, Your Honor.
Oh, thank you. Good morning. And we have Mr. Ferentz. Can you hear me? You got to pull over. I'm not going to hear your motion while you're driving. All right. And you have to unmute. We can start a little bit here, but are you at a spot where you can pull over, sir, soon? I can't hear you because you're on mute.
I'm texting him, Your Honor, and he is, because I just parked, actually. I told him to drive and pull over. I
Okay.
didn't know how.
Yep, he's pulled over, so we're here in 22-11915 DM Hutchinson versus Ferentz. This is a motion that has been filed by Ms. Coletti on behalf of the mother to split the proceeds from the sale of the marital home. There's already an order out there that requires you, Ms. Coletti, to hold the money that's been closed in your IOTA account. Is that correct?
Correct.
You're asking that it be distributed.
No, I'm asking that this be set on for an evidentiary hearing with regard to the distribution.
All
Mr.
right.
Ferentz increased the,
And that's about all I can do, quite frankly, is set some kind of an evidentiary hearing, because I understand that Mr. Ferentz incurred some more expenses on the line of credit and it's your thought that he's not entitled to do that and that'll all be his. It's my understanding that he believes that the money that he extended on the line of credit would all be, it was put into the house to make it more saleable, whatever the thing is, and increase the value. I, of course, have no idea one way or another what it was done. If it was put in, and then it would be reasonable that the parties split the proceeds after that is paid. If it was not put into the house, or if it was, in other words, if he put in another $20,000 and it didn't do anything to help the house, I'm not sure what I'm gonna do with that. But I believe, counsel, you've indicated that he put in to increase the value and make it more saleable. And so-
Yes, partially correct, Your Honor. I just wanted to add that also for marital debts too. However, I ask, and I do understand that there would be an evidentiary hearing needed to determine if that's legitimate or not. However, what we do ask for is that the January 4th order be set aside, the ex parte order to hold the funds, and then have the funds distributed, and then hold a hearing. So, and the reason for that, Your Honor, is because the judgment of divorce is, as Sister Counsel stated in paragraph 5 of her motion, that this is a written agreement by the parties and controls. And it specifically states that the
Sister
profits
Counsel
should be split between the parties. And that is in its own, and we have the profits and they
sister
should
wives.
be split. Anything else regarding the payments and reimbursement, and I do agree with Sister Counsel, there are issues for reimbursement and whatnot, and for the payment of certain debts. However, those are a separate issue that can still be done and should be done on separately.
She says Sister
rather than
Counsel one more
holding my
time.
client's share of the proceeds. Because what happened
I'm playing it.
is that my client relied on the profits, or to receive them when he wanted to close on a home that he is currently not able to close
Come on,
on
Rihanna.
because he does not have the funds to do so. And this is something that's irreparable harm to my client if we hold the money for the sake of the profits, for the sake of determining
Irreparable.
that.
That's
So
the word
I
you're
ask
looking
for
for.
that, Your Honor. I think that it could still, plaintiff's remedy and plaintiff's share is not going to be harmed. It's not going anywhere. She still has the right, despite
Well, it will, because once I give it to him, he's gonna put it into his house, and then he's gonna require months to pay it back. The court order that Judge Hillary signed said the parties appear on a to be announced for an evidentiary hearing with regard to division of the equity of the sale of home, and responsibility for payments on the line of credit. The two of you, Ms. Coletti and Ms. Diab, you can negotiate maybe a certain amount that can be let out, because you know X number of dollars is clearly gonna go, and I'm just gonna hold a certain amount that's in dispute. You can do that, but I'm gonna set up an evidentiary hearing. It's not gonna be a long one, because I don't really think it should be a long one.
Thank
and so we'll get it as quick as we can. However, Ms. Coletti, you've also asked for time for some discovery, which is appropriate. How much time do we need? Because the documentation has to be obtained from Mr. Ferentz and stuff like that regarding.
Correct. Yeah, and before he hired Ms. Diab, he said he was going to send me the proof that all the line of credit was used for the house, and that's really what I need to get from him. I need proof of what was spent on the house and whether the line of credit was used for something else. And then we also have other issues about whether Ms. Hutchinson approved it or what the agreement was to sell the house as is. So those are all
That's
issues
something
for an
I'm probably
evidentiary
gonna
hearing.
end up deciding, whether she did or not. And I'm kind of giving you some guidance when I say, if it was used on the house and it was used probably to increase the value or make it easily saleable, it's probably gonna be a responsibility of both parties. I know what your argument is, Ms. Coletti, and I know what other. I'm just giving you some idea of it right now, so maybe you guys can actually work this thing out. But Ms. Diab, when are you gonna get the information to Ms. Coletti? Because otherwise I'm gonna give her 30 days for discovery or something.
Your Honor, I already sent it. I'll resend it again. And Ms. Coletti, I apologize if you didn't get it. I sent out all of the documents that my client sent me for every ledger of the line of credit, every every transaction that was used since.
Okay. I've not received it, so if you would send it
Yes.
again, I'd be happy to look at it.
I
Yeah.
will give you 30 days for discovery, both parties, all right? We'll set up something. It's not gonna be a long one, and quite frankly, I'm hopeful that the two of you can get the documentation together at least. And we'll set up an evidentiary hearing of no more than 2 hours. And I will also meet with you probably a week or so beforehand to look over stuff and tell you probably what I'm gonna do.
Okay.
I just want to get this done, okay? The money's there, and if he legitimately spent it on the house, it does say to split 50% of the proceeds. If he didn't, then I can tell you what's going to happen to that, and I think just you know also what I'm going to do on that if you didn't. legitimately-
Absolutely, Your Honor. And I just wanted to add,
And if it
just so
didn't
you don't think
benefit,
that it was for marital debts as well. So there were two things that my client's position is, and that that will show that it was used for the home and to pay marital debts that were incurred. So that's the things that we will be
but
providing.
if that's, I'm just warning you, if that was the marital debt that's listed in there and he was using that money to pay it off, that was his responsibility to begin with, but we'll get to that. We'll set up an evidentiary hearing. 30 days is allowed for discovery. All right. Good luck,
Thank
everyone.
you.
Thank you. Have a
Thank
good
you, Anna.
weekend.
Thank you.
You too.
Trial. This is crazy. Ma'am, are you a whore?
Yes, it is.
You're not a whore? You're not a whore? You're not a whore? I never want to hear it again. Sweet Jesus. You're not a whore? Not a whore? You're not a whore? I never want to hear it again. It gets worse.
Both of you hear me all right, Miss Gates?
Yes, I can hear you.
All right, Mr. Gates, can you hear me?
Yes, sir.
All right, we're here in case 21-8782 DM, Gates v. Gates, both are present via Zoom. This was plaintiff mother's motion regarding custody. There was a default judgment. Divorce was entered 10/31/22, gave joint legal and physical custody. Parenting time as the parties agreed. Father's moved away from the Grand Rapids area down to Marshall. And basically, mom's asking for a request for custody. As far as parenting time goes, maybe I should refer that to the friend of the court. As far as custody goes, the order says judgment says either party may petition the court for parenting time when no longer living together. This is really what you're looking for, is parenting time, ma'am.
Yes.
And to be set, sir, what's your idea of what parenting time should be?
In all honesty, I actually went through, I have a calendar and I went through the rest of the 2024 school year and the beginning of the 23 school year and the next school year. And I went through and we've always done, I would get him on the weekends and then she would have him during school, obviously, because she's right there by the school. But if there was an email address I could send over, I have pictures of them already ready in a draft to be able to do so, to send to both of you guys, but it would break it down throughout the school year to where during the week he would be there with her, and then on the weekends I would get him.
Well, it's not always fair that you get every weekend, because then she never gets any time with the kid. As far as she sends him to school and brings him home, and then you get all the fun time on the weekends.
Right, I understand that. But as in she's requested in the paperwork and the motion was to get one of the weekends out of it every month. But that's fine. I was more worried and focusing more into the whole process of the summers and being able to do the switch. If he's not going to school and he's on summer break, I would like to be able to pick him and have him through the week and then switch it to the weekends for her until the school time would come again. And then as the holidays come up, there would be a division between the two of them, obviously.
Well, put it this way, if the two of you can agree on anything, you can make a stipulated order and send it in, and I'm sure I'm not gonna interfere with you, but if not, and it doesn't sound like there really is an agreement at this time, I'm gonna refer it to the friend of the court for them to do a parenting time recommendation. The only thing that it costs $150 from each party to go there. You have the funds to pay for that, for the friend of the court to do an examination?
Not currently.
Yeah, not currently at the exact moment.
All right, then I'll waive the fees. All right. I'll waive the fees, but you're gonna have to cooperate with the friend of the court. When they contact you, you need to cooperate with them, all right? Otherwise, they're only gonna get one side of the story.
Absolutely. Understood.
We'll send it to the friend of the court for parenting time, and as I say, I'll waive your fees.
Thank you.
Work with them on that, then if they will make a recommendation. If they make a recommendation and you don't like it, you need to object to it, because otherwise it'll become an order. All right.
Okay. Understood.
Okay, ma'am, you understand that?
Yes.
All right, we'll send it to the friend of the court and let's hope we can work something out for you. Good luck. All right. Thank you. We're
Thank
adjourned.
you.
Thank you.
What's next?
Well, that was disappointingly rational.
Yeah. Number 9's next.
Maybe we'll see.
Number 9. I looked over and saw. Number 9. Number 9. Famous Beatles album song, to any of those out there who are familiar with the Beatles. Number 9. Well, it's not much of a song, but I think it was on the White Album.
It was, Judge, but it's not as good as
The reason
this.
I want to check this is because defendant was here.
On this case, you're saying?
Yeah, hasn't been in it. Audio or anything?
Driving and everything. Miss Raywan? Elena?
Yes.
Can you hear me
Yes.
all right? Do you have video?
Yes, I can hear you. Yes.
All right.
Oh, good Lord.
This is the matter of Raywan versus Buckawing, case 22-10720 It's a motion that's been made. Mr. Buckawing was on this earlier, but has checked out, and we haven't been able to get him back. So this matter was originally scheduled for like 8:30. Like I say, he checked in and he checked out. This is your motion. You say you have it's a custody motion in which basically you're saying he should have custody, as I understand it, because quite frankly, you say you have medical issues that make it impossible for you to care for the child. You've also moved to Oklahoma. Is that correct?
Yes.
And so you want to give dad full custody?
Yes.
You also mentioned terminating your rights, but I cannot do that and will not do that here. All right?
Okay.
Oh, boy.
Do you know whether or not Mr. Buckawing objects to getting full custody?
He agrees.
All right. Then what I will do is we'll enter a custody order that gives him full physical and legal custody by agreement of the parties. All right?
Okay. Thank you.
All right. Thank you very much.
Wow.
All right.
Thank you. We're adjourned. Thank you.
Wow.
Stepped up the pace.
There sure is.
Number 10.
Number what? 10. We're going right
Yep.
down the list now.
Looks like she's made some changes in her life, if I had to guess.
I'm gonna go ahead and bring number 2 in as well.
Number what?
2. We'll see who.
All right, Tink, we'll have you take over. since you seem to know how to do this.
Guston, are you there? What is, Miss Bennett, can you hear me?
Yes.
All right, Miss Guston, can you hear me? Looks like hers is frozen. The Samsung. Miss Guston, can you hear me? Hello?
Problems with her audio checking her in.
Miss Guston, can you hear me? Is that Mr.? Sir, what's your name on the Samsung? Hello? Sir? Samsung?
Yep,
What's your name?
Joshua Bennett.
Mr. Bennett?
You want to do theirs first?
Yes.
Okay.
Miss Guston, can you even hear me? You're on mute. Just stay on mute for a minute. I'm gonna hear another case first and then stay there and I'll get right to you. This is case 19-5565. No, this is not 19-65. This is 23-12452 Bennett v. Bennett. This is both parties are present on Zoom. This is a request from mother for a ROPA hearing, if you will. However, ma'am, you said the child's not born yet. Is that correct?
She's not.
Can't do anything on that until there's a live birth.
A robot hearing?
Okay, so that's not what they told me here. They
Well, it
told
doesn't matter. I'm telling you, and I'm telling you that I cannot do anything until there's a live birth. When is the birth due?
Yeah, I don't care.
I scheduled C-section.
Pardon me,
I
you're
just-
breaking up.
I have a scheduled C-section, February 26th.
All right. After the child is born, you can come back and we can do a DNA test if you want.
Okay, so here's my other question. They had, obviously you're not the judge, but they had to let you know, because I'm in the process of our divorce.
Yep.
And so they said to let you know because they have me filed under children or, divorce with minor children.
Yeah, DM case, and if it's determined that Mr. Bennett is not the child's father, then we'll change it to a DO case, and you'll be over a lot quicker.
Well, that's the thing is, I have other children that are involved in this case, but I don't have custody of them and have not for a long time. So one of these ladies here told me to bring it to your attention to see if we can have it just the divorce without minor children.
Do you have other children with Mr. Bennett?
I have no children with Mr. Bennett.
I cannot change it to a DO case until I know that the child that you are carrying is not Mr. Bennett's. And that'll be done after you have a live birth. We will order DNA from Mr. Bennett and the child. Once that comes back and shows that he's not, we can probably change it to a DO case. That's just the way it's got to go, and I can't do anything until there is a birth of the child.
Okay, so that's what they told me this hearing for, is if he here and willing to tell you that we have not been together for a very long time.
I understand, but I got to follow the law that it states for me. You got to have the child born first. I can't do a DNA on it. Mr. Bennett, I'm assuming you say that child's not yours?
Correct.
All right.
Wasn't me.
I got to have the child born before I can find that the child's not. All right.
So he's automatically going to go on the birth certificate.
Renotice this after the child is born and we'll take care of it then.
Okay.
All right. Good luck, everyone. I'll look for a renotice. Good luck. Thank you. Miss Guston,
Yes,
has Mr. Burton ever been on or anything?
he has been trying to be on. He couldn't get it to work. I know that.
Yeah.
He was on it.
That's kind of why we're here.
He was on and he's not on.
Yeah, he was. Yeah, he was trying. He was texting my mom. He was trying to get on.
Well, this is case 19-5565 DS. Ms. Guston is the plaintiff. Mr. Burton is the defendant. He's been trying to get on. He apparently has texted several people saying he's trying to get on. There's a request by mom for full custody. She says she does everything for the kids. Dad's verbally abusive to mom. I don't know what you're talking about, the youngest child, because there's no showing that the youngest child is even his. I mean, I don't know what you're talking about on that one, because there's a young child and you say he doesn't pay attention, but is there another judgment somewhere that makes him the father of that child?
He is the father. I don't think he did a DNA test for either one of them, but he signed the birth certificates.
Doesn't matter if he signs the birth certificate. Did he sign an affidavit of parentage?
I don't think so, no.
Then he's not the legal father until that's done. Because you guys aren't married, are you?
No, we are not.
All right, well, regardless of whether the dad's on or not, because it doesn't really matter at this point, the judgment of support says the mother has initial custody and either parent may seek a custody order from that. And I do have that, I mean, that says that the father is the father of Nevaeh.
Yes.
So I have nothing else that I can do except set up an evidentiary hearing for custody, because you've requested a custody hearing and the support order says very much that either parent may seek custody from the courts. And so I'm gonna have to set up an evidentiary hearing on that. Although I guess what I would like to do is before I have the hearing, I'm gonna refer it to the friend of the court for custody, parenting time and support for their type of recommendation as to what is appropriate. I'll waive the fees of both parties so that you can go there, make sure that when the friend of the court contacts you, that you cooperate with them.
Yeah.
Mr. Burton is gonna be told the same thing. I would not normally proceed with this knowing that he's trying to get on, except it doesn't, no matter what he says, I have to have an evidentiary hearing. So doesn't matter whether he wants it or not, I have to. And in order to make a better decision, I'm going to refer it to the friend of the court, as I say, for physical, legal, custody, parenting time, and child support with the fees waived. All right?
Okay. Yes.
Look for contact from the friend of the court, and you got to do something about your youngest child because he's not the legal father of that child.
Okay.
Good. All right. Thank you. We're
Yes,
adjourned.
I say the words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
Miss Likely, can you hear me? Miss Likely, can you hear me?
Yes, sir.
All right, we're just waiting for Mr. Redmond to connect.
Okay.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
I never want to hear it again. Sweet Jesus.
You're not a whore? Not a whore? You're not a whore?
Kim, if you will put yourself on mute for a minute, we're gonna try and wait till Mr. Redmond gets in, and I'm gonna take another case, but as soon as I'm done with that, we'll come right to you, okay? So just put it on mute and let's see if we can keep this moving, all right?
Yes, sir.
Mr. Bigal, I'm not sure how to pronounce your name. James, can you hear me? You're on mute.
Can you just let this go for
James, can you hear me? Does it show he's connected? Show you're connected. You need to put on your video and you need to take off your mute.
Can you hear me now?
Yes, I can.
Sorry about that.
Did you send the notice of this motion to Kelly?
Yes, Your Honor.
You know when? While ago?
Sent it on the 10th of January.
All right. Do you know if she got it? I mean, have you talked to her at all?
I did not talk to her, but she has received it and she wrote a response letter that's been sent to me and to you as well.
No, I don't have a response, but I'll call the case. How do I pronounce your name, sir?
Bigaley?
Okay, this is Bigaley versus Bigaley, case 075278-DM. I have the defendant, Mr. Bigaley, on Zoom here. I've just asked him if he served the mother. He did. And he said, Ms. Bigaley has filed a response, although I don't. When did you get her response?
I received it on the 17th.
All right. Can you tell me what she says?
The letter reads, it says, to whom it may concern, then it shows the court case up top. On January 13th, 2024, I was notified via mail that my ex-husband, James Bigaley, filed the following motion with the court. Number 1, change custody of our son, David Bigaley, from me to him. Number 2, discontinue child support payments made to me because David will be residing full-time with his father, me. I accept both changes, is what she said.
All right. Well, and your son is here from Calumet, right?
Yes, he's staying with a friend until we get this all sorted out. He's been down here for about 3 months now.
Yeah, and is he going to come live with you or continue to live with a friend?
No, he's going to live with me.
All right. Well, under the circumstances, in order to change custody, there's clearly a proper cause or change of circumstance to have an evidentiary hearing. The problem that I run into is I'm mandated to have an evidentiary hearing to change custody. However, this child's already over 17 years old, 17 and a couple of months old. By the time I have a hearing and everything, he'd be 17 and a half. I mean, I only have jurisdiction over him till he's 18.
Right.
And mother's agreement that says that she, and I will, actually, raise your right hand for me for a minute. Would you please? Do you solemnly swear affirm testimony given in this case to be the truth, whole truth, and nothing but the truth?
I do.
All right, thank you. We were on Zoom here and it's all recorded. You just read me a letter from mother. You believe it's from her that agrees to allow you to have custody of your son?
Yes, it shows her signature, and she does wrote down and says, in regards to a possible request James makes in the future for me to pay him child support, I make roughly a third of what he does annually. His wife also works and has a third of a duplex they own. Please consider waiving the hearing upon receipt of this notice. I am self-employed and work Friday, January 26th. Attending the hearing would cause me to lose money I can't earn back. A copy has mailed via USPS to a friend of the court and James Bigaley.
I was mailed it to the friend of the court, which isn't the court, which was her problem.
Okay. Well, I talked to Julie. My wife
right. I understand there is a copy that's somewhere in the courthouse somewhere, and we'll agree to it. I'm going to do the unusual thing in that I never do this. I'm going to, based on the agreement of the parties, change physical custody of your son David to you, all right?
Thank you very.
With parenting time for mother as agreed between the parties, because it's gonna be agreed between you and your son and all that kind of stuff, all right? So we'll change that to you. I will at this point suspend child support payments promptly, all right, as of today. It may take a little bit of time till it gets, if it's being withheld from your check, it may take a few weeks till we can stop it, okay?
Is that filed paperwork, and then you'll send a copy to my employer to show officially stoppage?
Yeah, what happens is we issue this order to stop it. It goes, the friend of the court then has to contact the withholding firm, and they contact and
Gotcha.
you can, I will issue an order that hopefully by early next week you'll get a copy of, and if you can take it in and they'll deal with that, that's fine at work, okay?
Perfect.
But we'll do the best we can. You may still have to pay child support for a few weeks that you're actually entitled to get back. That'll be a question you might want to contact her and say that I've suspended it, so any more money she gets, she might have to pay back.
Okay.
But that's probably the least of your worries.
Yeah.
Worry right now is I will give you custody and
That's Kelly.
based
As long
on
as all
the
her fault.
agreement of the parties' custody, physical custody, legal custody will remain the same, and parenting time as agreed. All right?
Okay.
And
Another question. Excuse me. For my wife's insurance to put him on our insurance, they need documentation for insurance on the paperwork. Is that just something that they could use as well as to put him on our insurance?
I don't know what you mean. They need documentation. You're gonna have custody of them.
Okay, then that would be probably what they're looking for.
That's what I would think so. Okay?
All right.
We'll
Thank
get
you
it- You won't get this till at least next week, because we gotta draft it and get it out to you. All right?
Okay. Take your time.
We have a good address for you, right?
Yeah, 108 West.
Nope, that's all right. Don't say it. We're on YouTube.
Oh, okay.
All right, good luck.
He needs to
Thank
hold
you.
an evidentiary hearing,
Bye.
which he technically just did. Barely,
All right.
but enough. It's never gonna matter. The kid's
It's
17.
likely he just doesn't connect here. Is there
Parties
another one we
agree.
can do quickly before? We're still trying to get him to connect. We send him all kinds of messages. He's not connecting. I'm gonna keep you on the screen for a minute, because if he doesn't connect, I'm eventually gonna just go ahead, but if you can just wait there for me for a few minutes, okay?
Yes,
Do you
sir.
have a way of connecting to him? Can you text him or something and say,
I tried texting him this morning and didn't get a response, but he hasn't been responding to me since we haven't been agreeing on some of the things that've been going on.
all right. We'll keep trying for a few minutes here. All right, is the other party here, or is it just Channing?
Yes.
Channing Maldonado Santiago, can you hear me? If so, you gotta unmute and tell me that.
Yes, I can hear you.
Did you have a video? There you are, okay.
Yes, Your Honor.
Did you serve notice of this on Mr. Maldonado?
Yes, I did.
All right, you sent it to him by mail?
Yes, they told me to make a copy for him as well to send it in the mail for him.
And so you sent it to him when?
I don't remember the exact date, but I did go to the office and grab the copies, and the day that I grabbed these copies, I ordered it in the mail. So like the 7th of December.
Oh, all right, that's plenty of time. All right. This is a matter 19-7542 DS Maldonado Santiago versus Maldonado Santiago. Are you married to him?
We are still legally married, but we've been separated since my daughter's been 1 year old. I've never had any contact with him.
Well, you're asking for a DNA test. You were married to this to Mr. Maldonado at the time your child was born.
Yes, and I've asked for our divorce. I've actually filed for that as well.
Well, but that, I don't, when did you file for that? Here in
believe-
Kent County?
Yes, I did. I went to the legal aid assistants and they helped me file for this September 1st. We've previously had a court order for him to have a DNA test for me, but
And I don't know why, because you would have been married to him and we wouldn't normally do that.
yeah, he requested it for court, and the location that he had it was too far for me to travel, and I had been in a car accident and I couldn't reach it. And because of that reason, they left everything the way it was and made him pay child support.
Well,
Because we were
he's
still-
the father.
He said it
Yeah,
accepted.
because we were legally married, yes, but he's not the biological father. He was in a different state.
Well, then you should.
The reason for dissolution.
This case should actually be filed in your divorce case.
I
Not,
put that in my divorce, actually, on your honor as well.
well, the case number, what? I'll have to find your case number or something like that, because you're now claiming that he is not the father. And in your divorce case, I will order a DNA test to determine if he is the father or not. He still is the legal father right now until we get a DNA test. And I will send out an order for a DNA testing for him to.
Oh,
The divorce case is with Judge Gottlieb, so I'll have to work with Judge Gottlieb to figure this out.
My money's on this guy's
Okay.
not the father.
And see what we do, because if you're saying he's not, because up until now you're married and he is the legal father. We'll work with Judge Gottlieb and see what has to be done on that matter. Order a DNA test unless Judge Gottlieb does not want it. And
there's no way.
Send it out so that he has to abide by it. To the best of your knowledge, he lives in
My chat's connected
looks
to that.
like on Hyde Park in Maryland.
Yes.
All right, let's see what we can do. All right, I'll order DNA testing, but you'll get some information from Judge Gottlieb because she has the divorce.
Let him ring it
So that's what you're really dealing with now.
in court.
Yes.
All
I'm
right,
dealing with the divorce and the DNA test, and that's it.
you're dealing in the divorce case now, not in this case, not in
Okay.
the ES case. So we'll see what we can do. All right, good luck to you, ma'am.
Thank you, sir.
Thank you.
Have a good day.
You too. All right, Miss Likely, are you still there? Because Mr. Redmond is now here with us.
Yes, Your Honor, I am.
Mr. Redmond, can you hear me?
Yes, I can hear you loud and clear.
All right, this is the matter of Likely versus Redmond. Both parties are present via Zoom. It's case 11-6559 DP. This is a motion filed by Mr. Redmond. He says to go back and reread his stuff that he filed back in May of last year.
Ooh.
About it, he says that he wants a change of custody because
I hope there's a link for
the
that.
child's getting bad grades, which he now admits in the motion says they're better now. Says mom has changed her school, which she has the right to change her school.
This couple's in witness
The
protection.
child is on his lease. Says the mom is verbally and physically disciplines the child unless it's abusive. That doesn't matter. And says mom does not have a stable environment. Mother has sole legal and physical custody. An order from 2015. Sir, in order for you to try and change custody, you have to meet the burden of Vadvarka, which means there has to be a change of circumstance or proper cause. There's nothing in here that's been pled that would indicate that. What have you got to say as far as proper cause or change of circumstance?
Well, I mean, to elaborate on what you said, I really need to put emphasis on her schooling. I feel like she needs a chance. She needs a chance to even go to school. Like, she hasn't been going to school. I got records right here, stacks of records I had to go find because, I don't, just like you said, I don't have custody of her, but I did my due diligence and found all of her records that she has not been going to school. She from what, 2020. This is way back in
In your motion, you said she was getting bad grades, but she's doing better now.
So she's doing better since I've been in, since I got back in touch with mom, and that's just this year. But she still, they still said called me and talking about truancy, and I feel like that is a form of neglect.
Ma'am, is the child attending school
Yes, Your Honor, she is.
every day?
She has days where she misses partial days because Heaven has a bunch of health issues. She is type 2 diabetic with high blood pressure. She also has polycystic ovary syndrome. And I just recently found out that she's having some issues with her heart, which we are addressing. We actually have a couple appointments coming up, but Heaven goes to school on a regular basis. Her teachers will even vouch for that. She's a good student. She tries and puts all her effort into her work and her grades. She does struggle a little bit, but that's because she's ADD and ADHD. And then she's dealing with a lot of depression because with the PCOS, there's, hair that grows on her face, her neck, her chest, and her chin. She gets picked on by other kids and bullied about that. So, she does have her rough moments where she's slacking on her grades, but Heaven does her best to make sure that she picks up what she can and fixes her grades to the best of her ability on her own. And me and her teachers, we do discuss that frequently. Any unexcused absences can be shown in her doctor's appointments. Heaven does not miss school unless she has an appointment to go to, or she's not feeling well.
All right, Mr. Redmond, that's kind of a valid excuse.
That's not it. That's not entirely true. Cabernet is a very smart, intellectual person, and she is very amazing at painting pictures. And I'm not saying that a negative light at all with Cabernet. It's a beautiful thing, but just like I said, if you didn't hear me, I'm telling you, it's start. Even this school threatened truancy, and I have records of this. The whole first 2-3 weeks, probably a month or two, she did not attend school. And they said they will comply with me in the courts because just like I said, I do not have custody of Heaven, but in prior engagements, I have proof that we've been to court, and I was awarded joint physical. This is joint custody. This is back in February 28th, 2018.
This guy elaborates.
And you don't have this paperwork for some reason. And I got another paper right here that says I have joint physical custody. And this is dated back in August 2021. This date, and it is notarized.
What do you mean it's notarized? So what? It's not a court order.
But we did agree to have 50-50 custody. Me and the plaintiff.
The only legal documents that I have in the court file says that she has sole legal and physical custody. That's what's in the court order.
And I'm just saying that this is legal information.
Oh, good Lord.
What's the date on that?
This is some
I just told you it's
on.
2018. It's February 28th, 2018.
All right. So I mean, I'm looking for it. I don't see it, but
so
it's
my
not
point
the court
is,
file, and he knows it.
If it is a problem taking Heaven to school, I need physical custody, and if it is a problem and the plaintiff needs help, I am her father and I will take her to school, but I need the courts to acknowledge that Heaven needs help, and I am her father and I am here to help her.
That's fine, but you don't meet Budvarka.
You're supposed to help us
for a change of custody.
And Cabernet just agreed to me. I don't, hey, look, Cabernet just agreed to me yesterday. We had a conversation, and she said that every other week she's agreeing with every other week. I can get Heaven and take her to her appointments every other week. And now I'm saying, okay, that's physical. That's more parenting time. That's all I'm asking for is more parenting time and physical custody, so I can check on these appointments, go to these appointments, go to her school. I volunteer at her schools. That's how I know she's missing school.
All right, I've said this before, that your motion does not provide the VARCA information to change custody. I don't know. The only stuff that I have in the court file is her having sole legal and physical custody. If the two of you wish to come up with some agreement where mom is willing to change something about this and the two of you can agree to it, you can file it in a stipulated order that the court will review and most likely sign. But at this point, you do not have the proper cause or change of circumstance for change of custody. Ma'am, you can work with him on whatever it is that you want as far as having him help you out, getting him to school, getting the child to school. If you in fact do agree to some of this, I suggest that you write it down and you make it in a stipulation in order, and I will sign it so that he will have his guaranteed ability to do that. Do you understand that, ma'am?
Yes, sir, Your Honor. But
Alcohol.
I do have something to say.
Plain and simple.
What?
Mr. Redmond is in and out of Heaven's life. He only comes around.
It's all right. That doesn't matter. I've just made my ruling that there's not enough to change the custody. It doesn't make any difference at this point.
Thank
Whatever
you,
it is
Your
you're
Honor.
saying. So that's the order you can stipulate. I suggest you work with him. If he can help you out getting the child to school, let him help you. Good luck.
Yes.
We're
Thank you.
adjourned. Thank you.
Sure.
Oh, good Lord. That was something. That was something. She wears a bonnet and is the more reasonable of the two. I think that guy was trying to suggest he had a court order to a judge, but you know, which is real nasty stuff. Again, I'd be in jail for trying this stuff. Immediately. I'd be in the lockup at the court in cuffs
Church.
from the bailiff.
Hello.
Hello, do you have
I'm
video?
trying to pass an order off to a
Yep,
judge.
one
that
second. I'm
wasn't an
trying to get
order.
it here.
While you're getting that, this is 21-5702 DM Habor versus Church. There's a motion filed by Mother. Did you give him notice of this motion?
Yeah, and I actually talked to him about it on Wednesday. I reminded him of court today.
Yeah. What did he say?
He said, okay, I will turn on Zoom when I get in my car for work.
Well, we haven't seen him on Zoom at all. This is your motion. Or it says, I'm requesting documentation regarding a motion filed in October pertaining to Olivia Church being born on.
All right. All right. Judge Frederick, Magistrate Frederick, never disappoints. Never disappoints. It was fantastic. I do have to run now. Thank you all for coming out. I knew he had like a longer call. I just didn't know it would keep being good. That's what happens when I do these streams and they're live. And a lot of times it doesn't work out, but you see people waiting and you think, oh, I gotta see that appearance. For me, it was Bonnet Lady, who turns out to be Cabernet. And she was out there, but not as out there as Dad. Dad was more out there. Dad, I believe, we didn't get explicit about it, but I believe that was some sovereign citizen nonsense going on there. Because he's talking about because he's hyping up the notary. And he's just got some like documents that he's trying to sell as an order. I mean, that's straight up contempt for an attorney. Immediate contempt. To try to pass off something you scribbled up and notarized as a prior order. The judge suspected that. He's like, well, I don't see it. You know, like they don't know, like, you know, they've got a docket If you had a order entered from a prior motion or something associated with this file, it would be in the docket under the case number. Like, you know, we can verify these things. You can't just say, "Oh yeah, I've got an order." Like, even if it looked dopey, but even if it looked right, I mean, let's start with, you got to have a caption at the top. Like, the notary's not going to get it done. You need a judge's signature. And they know who the judges are. Unless it's from another jurisdiction, they know who the judges are. Oh, good Lord. That was just going down and down. All right. I got to run along right now. Thank you all for coming out. That was a fun morning. I'll see y'all soon.